Good morning, everyone. I guess we're going to go ahead and start with the seminar now. If you have any questions, just write it down and then maybe put it onto the chat. And then we'll try to, if we have time, or we'll try to answer all the questions that you have. Okay, so I'm going to go ahead and start now. My name is Peter Chai. I'm the lawyer on the second floor of this building. I practice a lot of real estate law, and also I do some family law as well. So I'm going to go ahead and start the seminar now. And we're going to discuss, today's seminar will be on family law issues for real estate agents. Okay, so we're going to go ahead. Now, to start out with, I'm going to talk about the concept of a matrimonial home. Since a lot of you are dealing with real estate, this is a very important concept that you need to know. What is a matrimonial home? Okay. It's defined in subsection 18.1 of the Ontario Family Law Act as every property in which...
Roger Lee, please come front desk. Roger Lee, please come front desk.
Okay, well, maybe we'll start that again. As every property in which a person has an interest, and that is, or if the spouses have separated, was at the time of separation ordinarily occupied by the person and his or her spouse as their family residence. So it's the family home of a, I guess, of married couples, right? So when you come across a married couple who owns a home, this should be coming up in your mind. Is it a matrimonial home? And just note that it has to be ordinarily occupied by the person and his or her spouse. So it has to be occupied by both the person that owns the property and the spouse as the family residence. Okay. Now, under subsection 19.1 of the Family Law Act, both spouses have an equal right to possession of a matrimonial home, even if only one spouse is on title. So it does not matter if you just have one of the spouses on title. Both spouses still have an equal right to possession of the matrimonial home. Okay, that's the first thing that you should be aware of. And also, you should be aware that a person and his or her spouse can have more than one matrimonial home. But note that in order to be a matrimonial home, the property must be ordinarily occupied by both spouses and not just one spouse. So you can have more than one matrimonial home. For example, the family residence, okay, in the city, and at the same time, the cottage that's owned by the couple or one of them can also be a matrimonial home. So you can have two matrimonial homes or more. I mean, you can have, like, I guess if you have a very rich client, like, maybe they own multiple properties. As long as that property is ordinarily occupied by both spouses as the family residence, it is considered to be a matrimonial home. Okay, so we're going to move on. Now, under Section 20 of the Family Law Act, couples can designate a home as the matrimonial home and register that designation with the Land Registry Office. This is often done when only one spouse is on title and the couple is going through a separation. The non-title spouse wants to put that designation on title just to give notice that the other spouse cannot sell that property without the consent of the non-title spouse. So it's just to give notice to people that, like the non-title spouse's interest has to be considered, all right? And I want to just go through a few points first, okay? Just a few, I want to highlight a few points about the matrimonial home, and then we'll go into the nitty-gritty about, what issues you need to consider about the matrimonial home. Now, under subsection 28.1 of the Family Law Act, okay, matrimonial homes only apply to property in Ontario. Therefore, any family homes located outside the province will not be given any special treatment as a matrimonial home and will be treated like all other family property. So if your clients own property in Hong Kong, in China, in the States, for example, those are never considered to be matrimonial homes. Only properties that are located within Ontario can be considered to be a matrimonial home. And likewise, if one spouse is the majority shareholder in a corporation that holds the title of a residential property, the spouse is considered to own that home for the purpose of the Family Law Act, and that property can be considered to be a matrimonial home if it meets the definition set out in subsection 18.1 of the Family Law Act. In other words, if it's a property that's ordinarily occupied by both spouses, okay, regardless if one spouse owns that property through a corporation, it's still considered to be a matrimonial home. Okay, so far everybody's good, and you guys are okay with what we're talking about here? I don't see any questions in the chat, so I'll just keep on going. Okay, and note that in dealing with the concept of a matrimonial home, the spouses must be legally married and not living in a common law relationship. So if the couple is in a common law relationship, for example, and they're living in a place, okay, if that's not considered, that place, that home is not considered to be a matrimonial home. The spouses must be legally married in order for us to be talking about a matrimonial home. And the other thing too, you should note is that a property may lose its status as a matrimonial home if it is no longer ordinarily occupied by the couple as their family residence. So let's say that the couple first lived in property A, okay, and then that property A would be considered to be a matrimonial home. But later on, they moved to property B and then rented out property A as an investment property. That property A would no longer be considered to be a matrimonial home. Only property B would be a matrimonial home. So just because the couple lived in that home for a period of time as a family residence, if they no longer live there as the family residence, it is no longer considered to be a matrimonial home. Okay, so now that we talk about a few points about the matrimonial home, I want to go through the important points now that you should be considering. The first thing you should consider is that under subsection 21(1) of the Family Law Act, neither spouse can sell or encumber, in other words, mortgage, an interest in a matrimonial home except by court order, unless the other spouse has consented or released their rights to the matrimonial home in a separation agreement. So if you're dealing in a sale situation, you're selling a property, and only one of the spouses is on title, but it's a matrimonial home because both the husband and the wife are living in that matrimony, in the property as the family residence, then you must get the consent of the non-owner spouse. And you often see that in the agreement of purchase and sale. There is a place for the non-title spouse to consent. Is that right, Sammy? That's right, right? Like in the agreement, there is in the signature page, there is a signature for the consenting spouse.
Yeah.
Yeah.
Listing,
okay.
Offer. Yeah.
Yeah. There's a place, and then you must get that that spouse who's not on title, but who's still living in a matrimonial home. You must get that signature. All right. They must consent to the sale. So that's point number one I want to point out. All right. If you're dealing, I just want to emphasize this point again. If you're dealing with a property that belongs to a couple, but only one spouse is on title, but it's the family residence, you must get the other non-title spouse to sign the offer, okay? Because they must consent to the sale. I think you guys probably go through that in your training, is that right? Yeah. Okay. Now, under subsection 21(2) of the Family Law Act, if one spouse does sell or mortgage the matrimonial home in violation of subsection 21(1), the court can set aside the transaction upon application of the other spouse. This is the case unless the person who purchased the property did so in good faith and was not aware the property was a matrimonial home. So this provision offers some protection to the buyer. So when a buyer buys the property, and let's say for some reason the non-title spouse did not consent and should have consented under subsection 21(1), and the buyer doesn't know this, then the buyer, it's okay. The buyer does not is taking the property free of the non-title spouse's interest, right? So it does give some protection to the buyer. So once again, I just want to point this out to you guys, okay? As real estate agents acting for the seller, you must obtain the consent of the non-owner spouse for the sale if the property is a matrimonial home. Okay, so far so good. I don't see any questions in the chat. So we're just going to move on. Now, either spouse can apply under subsection 24(1) for exclusive possession of the matrimonial home, even if that spouse does not hold legal title to the home. Now, when a matrimonial home is owned by one of the spouses, the second spouse's right of possession is a personal right against the first spouse and lasts for the duration of the marriage. A court order or separation agreement can actually extend that right. So you must keep this in mind when you're advising a legally married couple purchasing a property on how to take title. Often you'll find the case where the wife wants to go on title by herself, okay, without the husband being on title. And the wife may be under the mistaken impression that if something happens, let's say the couple separates, she can ask the husband to move out of the matrimonial home. Like basically, she can get exclusive possession of the matrimonial home. This is not in fact the case. Both spouses, even the one that's not on title, have an equal right of possession to the matrimonial home. So you want to, like make sure that you give the proper advice to your clients, like that, even though only the wife is on title, for example, okay, later on in the event of a separation, the husband still has an equal right to possession of the matrimonial home. The wife cannot ask the husband to move out, okay? So because both the wife and the husband have an equal right to possession. So that's point number 2. I want you guys just to keep in mind. And the last point is actually the most important point. I want to deal with how the matrimonial home is treated during a division of property, or what we call the equalization process when a couple separates. In Ontario, the matrimonial home is treated differently than all other assets under the equalization process or the division of property process. Its value is never deducted from a spouse's net family property as a date of marriage asset, even if that spouse did own the property at the time of marriage. But the home's value is always included in the valuation date assets of the spouse who owns the home, or divided between the two spouses if title is held jointly. This has the effect of making the home owning spouse's NFP substantially higher than it would be if the home were deducted as a date of marriage asset. So just to be clear, if one of the spouses is bringing the matrimonial home into the marriage, in effect, the value of that matrimonial home will be divided into two, okay, right away. And we don't want that, because a lot of times I find the spouse, like one of the parents is helping the children out to purchase a property, and then that child may eventually get married and bring that property in as the matrimonial home for his for his marriage. But then you're putting the parents' money at risk, because the parents really bought the property. But then when they just a minute, Sammy, can you tell these, like, can you tell them to roll up, please? Okay, just give us a second here. We just have a. Okay, like I was saying, often you find the case, it's the parent is helping one of the children to buy a property, okay, and that child's the son or daughter, for example, is not married, and later on that child will bring that property in as the matrimonial home for his or her marriage, but the parents is the one that really bought the property and put the money into the property. Now, if that child brings the property into the marriage, then in effect, you're putting the parents' money at risk, because in the event of a separation between that child and his or her spouse, that the property itself will be, the value of it will be divided into two. So the wife or the wife or the husband of that child will in effect get half the value of that home, even though the parents put all the money into the property. So we don't want this, okay? And I'm going to go on and explain this a little bit further here. Okay, I'm going to talk about what happens during an equalization or division of family properties upon separation. Okay, in very simple terms, when a legally married couple separates in Ontario, there is an equalization of the couple's net family properties under the Family Law Act. Okay, each spouse's net family property is determined by his or her net worth. value of assets minus value of liability at the date of separation minus his or her net worth at the date of marriage. Now, keep in mind, this is a very, a simplification. There are excluded properties and deductions that we're not discussing here. I'm really simplifying this process. Okay, there's more to this, but I'm just simplifying the process for now, just so you can understand the concept. Under subsection 5.1 of the Family Law Act, when a divorce is granted or a marriage is declared nullity, or when the spouses are separated and there's no reasonable prospect that they will resume cohabitation, the spouse whose net family property is the lesser of the two net family properties is entitled to 1/2 the first difference between them. So I'll go ahead and give you an example of this. Okay, for example, let's say the husband's net worth at the date of marriage was 100,000 and his net worth at the date of separation was 600,000. The husband's net family property will be 500,000, okay? 600,000 minus 100,000. And then let's say the wife's net worth at the date of marriage was 100,000 and her net worth at the date of separation was 400,000. The wife's net family property will be 300,000. So the difference in the net family properties is 200,000, and then the husband would be liable to make an equalization payment of 100,000 to the wife. That is the case, okay? In like once the couple separates, okay, the wife can come and say, I want to have a division of the property or an equalization of the properties, of the net family properties, and then give me the 100,000, okay? Because that's the difference in the net family properties, 1/2 the difference. Now, let's say that the husband's net worth at the date of marriage consisted of the matrimonial home with a value of 100,000. He would not be entitled to deduct this amount as a date of marriage asset, so his net worth at the date of marriage would be 0. At the same time, he must include the value of this matrimonial home in his net worth at the date of separation. So his net family property at the date of separation will remain at 600,000. The difference in the net family properties of the husband and the wife now would be 200,000, and the husband would be liable to make an equalization payment of 150,000 to the wife. So in effect, he would be liable to make $50,000 more because they're now splitting the value of the matrimonial home at the date of marriage. He's not entitled to claim it as a deduction. He must split half of the value of the matrimonial home, which is 100,000. So instead of paying 100,000, now you have to pay 150,000. So you have to understand this puts the parents' money at risk because now 50,000 of the original of the purchase money is now going to the wife, and I don't think anybody really wants this, right? So you must take note of this if you're acting for maybe a young adult, okay, and you know that the money to purchase this property is really coming from the parents. You must give this type of advice to your client. Say, well, look, you know, this may happen later on if the purchaser, the young adult, brings the matrimonial home into the marriage, then the parents' money may be at risk. Okay. So far I don't see any questions in the chat. So I assume that you guys are all comfortable with this, with understanding this. It's very simple. You know, you just have to keep this in mind. Okay, it's not a, it's something you just should be aware of and just keep in mind when you're advising your purchaser clients. Okay, also remember that under the definition of matrimonial home, only a home ordinarily occupied as a family residence at the time of separation constitutes a matrimonial home for the purposes of the Family Law Act. Homes that were once the matrimonial home, for example, when the parties were first married, but are not at the valuation date, the separation date, are accorded no special treatment under the Family Law Act. So, like I said before, a matrimonial home can lose its status as a matrimonial home if the couple is no longer residing at the property as their family residence. Okay, so it could be that at the time of separation, on the date of separation, the parties are not occupying the property as their family residence. Then it's no longer considered to be a matrimonial home, and the value of that property can be included as a date of marriage asset. So once again, just to emphasize this point, okay, you must advise your purchaser client if he or she is purchasing a property that may become a matrimonial home at a later date of the rights of the non-owner spouse to 1, consent to the sale or mortgage of the matrimonial home, 2, to equal and exclusive possession of the matrimonial home, even though that non-owner spouse is not on title, okay? And 3, that the value of the matrimonial home will be in essence divided equally between the spouses in the event of a separation, even if the owner spouse had paid the entire amount for the property and owned it before the date of marriage. Okay, so you must advise your purchaser client of these 3 points. Okay, then often I get I get the client asking me, well, how do I protect myself? Like how do I protect my parents who really bought the property? You know, how do I protect their purchase? How do I protect their money? Because obviously, in the event of a separation, you do not want half of the value of the matrimonial home to be going to the other spouse, right? You don't want that. So to protect the client, consider the following. 1, you can have a domestic contract, i.e. a prenuptial agreement. So you can have a marriage contract that's signed by the parties before the date of marriage, okay, like before they actually get married, that would in essence say that the non-titled spouse gives up his or her right to an equalization of the net family properties. Okay, so you can have a domestic contract that would protect the titled spouse from the claims of the non-titled spouse in the event of a separation. So that's the first thing you can do. But just keep in mind that it's very difficult to ask the couple to sign a prenuptial agreement before marriage. I find that it's very, very, very difficult because you know the couple in essence like they're in essence getting married, and nobody ever thinks about separation when they're going to when they're about to get married, right? Nobody ever thinks the worst and say, well, what happened if we separate? Because everybody's thinking we're gonna go into the marriage and it's gonna last forever, and you know there's no need to consider what happens if the couple does separate, right? So it's very difficult to ask the couple that's about to get married to enter into a prenuptial because it's very awkward in that case. So the other thing that you could ask is you could request the non-owner spouse to purchase a half interest in the property from the owner spouse. So that way, you can then return that half interest back to the parents. Okay, so you can say to the one that's not going to be on title, pay me half of the value of the house. But that's also very difficult as well, because like I said, it's very difficult to ask for these type of arrangements to take place before the couple gets married, because most of the time when you're about to get married, you don't think, like what's going to happen in the event that we separate, because that's just not something that the couple will consider. The other thing you could do, the third thing you could do, is you could mortgage the property. So what happens is the child purchases the property and then gives the mortgage back to the parents for the full value of the property. All right. So let's say the parents bought a $1 million property for the child. The child then can give a $1 million mortgage back to the parents. So that way you reduce the value of the matrimonial home down to zero. The equity will be down to zero. But it is very important that the mortgage transaction and the documentation take place at the time when the purchaser or the client is purchasing the property, and not at the time when he or she is about to separate. I find that a lot of times I get people coming to my office and they say to me, the parents put money into buying this property, and the couple is about to separate now. Can we have the child, like the child that purchased the property, give a mortgage back to the parents to try to reduce the value of the matrimonial home? And I say, well, that's not, it's going to be very credible, not going to be very believable because, you're doing it now. You should have done it, when the client bought the property, right? That way it would look a lot more, authentic, right? I mean, if you're doing it now, it looks like you're doing it just so that you can defeat the claim of the non-title spouse to the property, right? Like you should have done this when the child bought the property and not at the time when he or she's about to separate. And the other thing you could consider doing is you could bring cash into the marriage and then you can buy the matrimonial home after marriage, right? So then the cash would automatically be deducted as a date of marriage asset. So you can deduct that from the net family property. So that's something else you can consider as well. You have the child bring cash into the marriage and then make the purchase of the property after marriage so they can get that deduction for the cash. Okay, I know I'm going very, very quick here, and I know there's a lot of concepts here. Do anybody have any questions right now? Like anything that they're not sure about, or any further questions at all? I don't see anything.
I have a question. Hello,
who's this?
I have a question.
Who am I speaking to? Can you say your name?
Yeah, my name is Daisy. I have a quick question about the mortgaging the property back to.
Actually, first of all, do you understand what we're talking about so far? Like all the concepts?
Yeah.
Okay, go ahead.
Yeah. For example, if I'm buying a house for my son, I'm paying for the house, and then how can I mortgage the house? Saying my son is owning the mortgage to me.
Well, your lawyer would just give a mortgage back. I mean, that could be done very easily. The mortgaging of property could be done at the same time as the purchase.
Okay.
So they can give a mortgage back, but then in this case, sometimes you run into the problem because if you're getting a mortgage to buy the property in the first place, let's say you're getting a mortgage from, say, BMO to buy the house. Often the BMO or the financial institution that's giving the mortgage don't want a second mortgage on the property. So when you're talking about the situation, you're mortgaging a property, you're talking about a property where you buy it without a mortgage. So that way you don't have any restrictions. Do you follow?
That's not my question. Okay. My question is that I have the money, for example, $1 million. I have the $1 million. I'll pay for the property, but I'm going to give this let my son to live in the property. I want the property to have his name.
Your son is not married, right?
He's not married yet, but he's going to be married.
And is he going to bring this property into the marriage as a matrimonial home?
Yeah, maybe, but I don't want they get separate and then his wife split the value, because I'm paying for it.
Well, like I said, you consider these there's some ways to protect yourself. Like you can have the son and his future wife sign a prenuptial. Okay.
Okay.
That's one thing. You can have them sign a domestic contract. Okay, as a condition for marrying. Okay, and then your son can just explain to the wife that, look, this matrimonial home, the money really came from my mom, and I don't know, I had to protect my mother, right? Like you can have, him explain that, or you can have the wife purchase 1/2 interest in the property from your son, so you can have the wife give $500,000 to your son, although that's kind of difficult too, because I don't think it's like.
Yeah, I understand that's difficult. Yes.
Or you can have the property mortgage, so you can just go to a lawyer and say, I want the son will give a mortgage back to me for the $1 million, right?
Okay, only when they separate.
No. That's what I'm trying to emphasize. It should be done at the time when your son is buying the property, and not at the time of separation. Because if you do it at the time of separation, it'll look kind of fake, right? It'll look like it's not.
Yeah, I understand. I can do it when purchase the property. But okay, I'm just protecting me if they separate.
That's right. So you can have a mortgage from your son back, and then you have to have all the proper documentation. So you have to show that the $1 million came from your bank account. Right? So you have to show that it's a real mortgage. It's not just like documentation that's made up to defeat the wife's claim, right? You have to show that the money for the $1 million came straight from your bank account, went to the son to buy the property, then you have to have a mortgage. But it should be done at the time when your son is buying the property and not at the time of separation. And it's
I
not
understand.
believable.
Yeah. Do you this type of service?
I'm sorry?
Do you do this?
Yeah, I can do this. Yeah.
Yeah.
I mean, when
What
you
about the
buy the
fees?
property, we just have a mortgage back to you. I mean, that could all be done at the same time as the purchase.
Okay. Thank you. Understand. Okay, thanks.
Do anybody else have any other questions? I mean, I know, excuse me, I know we're going kind of fast and quick, and I know there's a lot of things I've discussed. That's why I want to make sure if everybody's comfortable with what we're talking about and everybody understands the concepts.
Oh, hi, Peter. My name is Jen. I have a quick question. All the law you're talking about, the family law, is also applied to the common law, like a couple. It's not.
No, it does not. The matrimonial home only applies if the couple is legally married.
Okay.
If the couple is living, is not legally married, okay, they don't have a marriage certificate, for example, then it does not apply, okay? Only when they're married, legally married.
Oh,
Yeah.
so that's why a lot of young people, they don't want to get they just come along. Okay, I understand. Thank you so much.
Okay. So once again, this is only if the couple is legally married. If they're in a common law relationship, then there is no concept of a matrimonial home in a common law relationship, only for legally married couples. Okay, any other questions at all?
Yes, Peter, can you hear me?
Yes?
It's Lisa. I just want to ask, is matrimonial home the same as a principal resident? Are they the same?
Yeah, kind of, because I mean, well, the principal residence is dealing with the
tax.
residence where you live primarily, right? But
Yes.
a matrimonial home, you can have a matrimonial home, a primary residence, and you can also have a secondary residence, as long as the property is ordinarily occupied by the couple as their family residence, then it's considered to be a matrimonial home. Whereas I think a principal residence deals with the place where you live the most, right? So it's not really the same, no.
So if you own a house and then a cottage, which you go on the weekend every week, that cottage was used on the weekend, Friday, Saturday, Sunday, they will be considered matrimonial home. And
yeah,
also
it may not be considered to be a principal residence, because I think the principal residence is the place where you live the most.
Okay.
But it would still be considered to be a matrimonial home, because it's a place where you guys the couple ordinarily occupy.
Yes. Okay. Yeah. Thank you.
Okay, do you have any other questions?
Yeah, Peter, I have a question. This Jen again. And how about except the principal home, the parents also give the son another house. So but the wife is not entitled on another house. So when they separate, they also the wife has the right to share the.
No, remember, we're talking about a place where the couple, like a matrimonial home is the place where the couple ordinarily reside as the family residence. So if you bought a property and you gave it to your son and the son rented it out, it's not considered to be a matrimonial home, no.
Okay, so even they get separated, the wife don't have the right to ask the son to sell and to separate to share.
No, because
Okay.
it's considered to be like any other property. It's not the special property that we're talking about here. Like a matrimonial home is a special type of property. In order to be a matrimonial home, the couple has to be living there as their primary residence. So if the property is a rental property, an investment property, it's not considered to be a matrimonial home.
Oh.
Hello? Jen, are you still there? Okay, I guess maybe she's finished. Any other questions?
Oh,
at all?
yes, I'm finished. Sorry about that. Thank you.
Okay, any other questions at all? I want you guys to be very clear about what we're talking about here. It's a matrimonial home. It's a special type of property that's treated under the Family Law Act. If it's a rental property, an investment property, then it's not a matrimonial home, okay? And also, if the couple is not legally married, then there's no such thing as matrimonial home in a common law relationship. Okay, yeah, so these concepts are very important, like, because I mean, when we're talking about real estate, we're talking about houses, we're talking about condos, right? So, you know, like, you really need to put your mind into this when you're dealing with a situation where you think the house may be a matrimonial home or may become a matrimonial home. You really need to address these issues with your clients, what we just talked about. Do we have any other questions, or do we want to move on? Because this is probably the most important point I want to emphasize in today's seminar, the concept of the matrimonial home. I mean, don't feel shy if you don't understand this, or if you want me to explain something a little bit further. Just, you know, just speak up. Okay, so I think we're going to move on. It seems like we have no other questions about the matrimonial home. So okay, so lastly, please note that the concepts of matrimonial home and equalization only apply to legally married spouses and not to common law spouses. So this thing that we're talking about the equalization, okay, and the other word for equalization is the division of properties. Okay, and the concept of matrimonial home do not apply to common law spouses, only to spouses who are legally married. However, a non-owner common law spouse may be able to claim from the owner spouse if he or she has made contributions to increase the value of the property, for example, renovations. So if the non-owner common law spouse put $100,000 into the property, okay, for example, to fix it up, okay, then that non-owner common law spouse may be able to make a claim against the owner spouse and say, look, I put $100,000 into this property. Okay, I'm entitled to get some of it back from you. All right, so that is one way for a common law spouse to make a claim for an interest in a property if he or she has made contributions to increase the value of the property. Okay, now I want to talk about the concept of a joint tenancy versus tenants in common. Okay, now if you're acting for two or more purchasers, okay, do you want to know how they're going to take title? Are they going to take title as joint tenants or as tenants in common? In a joint tenancy situation, all the people that are going on title, all the purchasers that are going on title, they all own the whole property. But when one of the purchasers dies, then the property then just goes to the survivors, the remaining purchasers, the remaining people on title. All right. So let's say, for example, my mom and I bought a property together. Okay, we're going on as joint tenants. Okay. When my mother passes away, that property would go to me directly. Okay, we just had to register a death certificate on title. So we registered my mom's death certificate on title, and then that property will go to me automatically as my property entirely. Whereas in a tenants in common situation, you actually assign specific percentages to each person that's going on title. So for example, in the same situation, if my mom and I were to buy a property and we were going on as tenants in common, then I would, like, let's say I want to own half and she wants to own half. Then I would own a 50% interest in the property, and my mother would own a 50% interest in a property. And when one of us dies, okay, let's say, for example, my mom passes away, that 50% interest of my mother's will go to her estate. It won't pass to me. So I'll still own 50% of the property, and then my mom's estate will own the other 50%. All right, so you actually assign specific percentage ownership in a tenants in common situation. Whereas in a joint tenancy, all the people who are on title, they all own 100% of the property, and then when one dies, the survivors, end up owning the property still. All right, so that's the difference. And if the couple is legally married, they often go on title as joint tenants. Okay, whereas if the couple is a common law couple, I find that it's often better to treat them as tenants in common. So each person would own a specific percentage of the property. And the same thing if brothers or sisters are buying properties, okay, I often put them on as tenants in common because you want them to be assigned a specific percentage so that when they pass away, instead of their interest going directly to the other people on title, it would just go to the estate. Okay, so does everybody understand the difference between joint tenancy and tenants in common? Okay, and this is something else you need just to be aware of. I just want to bring this point to you. Under subsection 26(1) of the Family Law Act, if a spouse dies owning an interest in a matrimonial home as a joint tenant with a third person and not with the other spouse, the joint tenancy shall be deemed to have been severed immediately before the time of death so that the spouse and the third party become tenants in common. The interest of the spouse would then be passed to his or her estate. This is done so that to avoid a situation where the owner's spouse will pass his or her interest in a matrimonial home to a third party instead of to the non-title spouse. Okay, so if you have a situation where you have a client, like let's say a son owns the property with his parents, okay, or with one, let's say with his mother, okay, so the son and the mother are on title, but the property is a matrimonial home. Once the mother passes away, the property will not go directly to the son, and vice versa. If the son passes away, the property will not go directly to the mother. It will be split so that it will be treated as a tenants in common, so that the son will own 50% and the mother will own 50%. And then the son's interest, that 50% interest, will go to his estate. Then his wife can then make a claim for that 50%. All right. So I find that sometimes people try to set this up. Okay, they try to set it up so that instead of the other spouse going on title, the owner's spouse will just go on title with his relative. For example, the husband will go on title with his mom, and they think, oh, something happens to the husband, the property will go directly to the mother, and then the wife will get nothing. But this is not the case. If it's a matrimonial home, then the property will not go directly to the mother. It will be split so that it will be treated as though the son owned 50% and the mother owned 50%, and then the 50% interest of the husband will then go to his estate, and then his wife will then be able to make a claim for that 50% interest, because his wife will have a claim against the estate of the husband. Okay, does everybody understand this point? Like this is something else you guys should just keep in mind if you're acting for people who are buying properties. Lisa, do you understand this issue at all? Like,
Yes, I understand.
and
Thank
like
you.
anybody else, Jason, Jin, like you guys understand this? Like,
Yes, I understand. You
okay,
can keep
good.
going.
So we can move
Thank
on.
you.
Now, there's a few other things I want to talk about in before the I guess we have over 15 minutes. Just a few other things I want to talk about. You may be acting for a couple who may be in a process of separating or getting a divorce when they're selling their home. In this case, you should ask to see a copy of the separation agreement and or court order authorizing the sale. Okay, and you got to note that the parties will probably be adversarial to each other. So when a couple is separating, they're very, they're very adversarial towards each other. They often have very strong emotions, for the other person. Okay, and then you have to kind of be very sensitive to that. All right, and you just have to, like sometimes I find that it's the case that sometimes the I don't know in your case, but I find in my case sometimes the wife and husband, they want separate lawyers in dealing with the sale. Like they want, husband wants his own lawyer and the wife wants his own or her own lawyer when they're selling the property. Okay, and of course that drives up the cost. So you tell them, like the cost is you're going to be paying legal fees twice, one for the husband's lawyer and one for the wife's lawyer, and often, they'll come back to the census and say, okay, we'll just have one lawyer do the sale. But I don't know if it's a case where if you're acting for a couple that's separating, whether they actually want different agents as well. I don't know. I don't know if you guys ever come across that. Have you guys ever come across that at all? Like where you find that the couple that is separating, they each want their own agents? Lisa, did you?
When they don't separate, they want their own agent. Never about separation. They just look at the cost of how much the other agent charge.
Yeah, then they'll come back to the sentence and they'll say, okay, we'll just we'll just hire the one agent or the one lawyer, right?
Yes, everything is go to the bottom line, you know.
Okay, and you should also know the difference between separation and divorce. Okay, like a lot of times I find people say, or like they refer to the other spouse as the ex. Okay, but a divorce, you only divorce when a court grants a divorce. Just because you're separated from each other doesn't mean you're divorced, right? You may be separated from each other. Okay, you may even have a separation agreement, but then in order to get the divorce, you have to apply to the court to get the divorce. So until you get the divorce, you're still considered to be married to each other. All right. So just note that difference as well. All right.
I have a friend who is on the situation that they have been they get married, okay, and they came here from as an immigrant, and then after a while they get separation. They separate, okay, but they don't do a legal document for separation, but they just don't talk to each other in the house for now about more than 10 years, okay, and they don't sleep together. They don't, they just have one children, and then is it considered separation? But they live together but separate bedroom and they don't talk to each other, just like someone else.
Well, yeah, they are a separated couple. You don't need a separation agreement to be separated. I mean, you can be separated from each other. You don't need to have legal documents to say you're separated. Although it's better to have legal documents. That way, your rights and obligations can all be spelled out. Like in terms of child support, custody, property. Like that's all put in writing, right? But I mean, you can still be separated from each other physically. I mean, you don't need a document to say you're separated.
Okay. So.
But you do need to apply to the court to get the divorce, though. Okay, so if you want to say I am not a spouse, okay, I am no longer a spouse, you need to go to court to get this divorce. Until you get the divorce, you're still a spouse, although you're separate.
Oh, okay. Okay. Even they are separate, and then whatever the other.
I mean, if they were legally married to each other, they're still spouses of each other, right? It's only when you get the divorce, then they're no longer spouses. Yeah.
Oh, so even there's no relationship, they still be considered liable for each other.
I'm sorry, I thought you said they're legally married. Are they legally married?
They are legally married in their own country. When they come here, they after a few years they become not getting along, but because they cannot move out, so they have to force to leave. But they don't talk to each other. They don't do anything together.
No, like I said, in that case, they are still spouses of each other, but they're separated spouses. But they're still spouses of each other.
Okay.
So my question is that all the law is applied to the separation or only applied to the divorce, the legally divorced?
No, divorce itself is just a status. Okay, it's just to clear up your status. Your rights and obligations are done through a separation, but then the divorce itself is just to deal with your marital status. Okay, so like once you're divorced, you're no longer married. Okay, but then like your rights and obligations is usually done through the separation. So your rights to custody and access of the children, your property rights, your rights to child support, to spousal support, all that is done by way of a separation. Yeah.
How about the house value? They separate. They just separate. Has not go to court to get the legal like divorced. So they sell.
I'm sorry. Can you speak up?
Yeah, and I mean that's they just separate. It's not legally divorced. So when they sell the house, the value equally like separate equally. Is only applied to the divorced couple or just
No,
also
no,
apply to
no,
the
no.
separate?
The property division applies once it's separated. The
Oh, okay.
equalization applies once it's separated. It doesn't just come into effect during the divorce. Like I said, the divorce is only a status to change your status, all right, from married to not married, okay? But the all the other rights like equalization, the division of property, you know, custody and access, child support, alimony, like spousal support, all that takes effect once the separation, you know, comes into effect. Yeah.
How to approve they are separate? Like some people,
Well, like I said, like they could be separated from each other, but it's better to have an agreement, like a separation agreement, so that you know, like everything is spelled out in writing to say that they're separated.
so has to be live in different the place, right?
No, they don't have to live in a separate place. I mean, as long as
Just
like,
agreement.
I mean, as long as like it's hard to tell you exactly what separate means. But I mean, they don't have to live in the same, they don't have to be living in separate houses in order to be separated. I mean, they can still be living in the same house as long as they don't do stuff as a couple, right? Like you know, like it's, I don't really want to get into that, but I mean, you know, like
It's-
you know, like you can usually tell when a couple is separated. Like you can usually tell, like you know, like that they're separated
Okay, it's
from the facts. Yeah.
yeah, when they try to separate the value, that will be more complicated. Okay, thank you, Peter.
Okay.
Thank you.
Okay. Okay. So I just want to note that not all relationships have family law implications. For example, a girlfriend-boyfriend situation without children usually triggers no legal obligations. On the other hand, legally married spouses, including same-sex couples, would trigger the most legal obligations, including property rights such as equalization of net family properties and matrimonial homes. Remember what I told you before, like the equalization, the division of properties and the matrimonial home, like concepts, those only apply to legally married spouses. Okay, common law spouses, it's usually defined as those couples who are not legally married, but have lived together continuously for a period of not less than 3 years, or are in a relationship of some permanence. If they, for example, if they're parents of a child, usually do not have property rights against each other, okay? So legally married spouses is the top, okay? And then common law spouses, and then you have the boyfriend, girlfriend situation at the bottom, all right, in terms of legal obligations and rights. So a lot of times I'll get calls from people saying, oh, this is my boyfriend. And, you know, like, you know, and they'll ask me stuff about family law. And I usually tell them, well, look, I mean, it's just a boyfriend situation or a girlfriend situation. You know, there's usually not very much in terms of family law implications. Okay. But then, you know, like, so just keep these things in mind as well. I find with most Asian couples, most of them are legally married. I really deal with common law situations. Okay, so you know, like I find most of the time in my practice, I'm dealing with legally married spouses. However, the law treats legally married spouses and common law spouses the same when it comes to issues of child support and access, child custody and access, child support and spousal support, example, alimony. Both types of relationships have the same rights and obligations when it comes to these issues. So when it comes to custody, access, child support, spousal support, both legally married spouses and common law spouses are treated the same. Okay, I won't get into the issue of like custody and access and support issues, because I mean, that's not really relevant for you guys as real estate agents. Okay, lastly, I want to just discuss the different types of domestic contracts under Part 4 of the Family Law Act. You could have a marriage contract, okay? It's a contract that's entered into before the couple gets married, okay? And it would spell out stuff like spousal support, division of property. You could say that, you know, like one of the spouses is not entitled to a division of property, for example, like they give up the rights to equalization. right? And then that's the marriage contract. And I find that it's very difficult to get a couple that's about to get married to enter into a marriage contract. The optics are just not there. Like it's very difficult, you know, a very difficult situation to ask, you know, like people who are about to get married to enter into a marriage contract, you know, to say what happens in the event the marriage, you know, is ended, right? Like that's a very difficult contract to get okay. Cohabitation agreements, it can deal with the same issues as the marriage contract, okay? And a cohabitation agreement is usually done when the couple is married, but they're not separated, okay? You can spell out stuff like, you know, like in the cohabitation agreement dealing with finances, for example, you can sit there and say, you know, like all the finances, like all the bank accounts, investments, all the properties of the wife will remain the property of the wife, and the same thing with the husband, okay? Like that all the assets of the husband will remain the assets of the husband, okay? This is taking place during the marriage, okay? Okay, it's called cohabitation agreement. And then the last thing you can have is a separation agreement. And these agreements are done after the couple has separated. So you can have a contract before marriage, during marriage, and after the marriage is, you know, about to end, like through a separation. Okay, so these are the three types of contracts. And I think we have about a couple minutes to answer some questions. That's the end of my seminar. I hope you guys actually got something from it. And if you have any questions from the seminar that you don't understand, okay, that you still have some questions, just feel free to give me a call. Okay, and I guess we might have time for just a couple more questions if anybody has any questions they want to ask. Is that it? Okay, well, thanks so much for attending, and feel free to give me a call if you still have any further questions. Okay, or email me. My email address is here, and my phone number is here as well. Okay, thanks so much.
Thank you.
Thank you, Peter.
Okay, thank you.